rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV18-0141, ORAM versus ORAM. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal. If you decide to do so, please keep track of time yourself using the clock on the podium. These proceedings are being audio and video recorded, so we would be grateful if you, when you approach the podium, would identify yourself and your client. We have read the briefs, discussed the case this morning in conference, and are familiar with the arguments raised. So with that, counsel, you may proceed.
Thank you, Your Honor. Your Honor, myself and opposing counsel, Mr. Riley, we did have one preliminary issue, if we may address the court with that first.
Sure.
We did agree to...
Oh, could you go to the podium so we can...
We did agree to set aside the court's order, and we filed a stipulated motion to set aside the court's order, striking the reply brief. Did the court receive that?
Counsel, I can't tell you that the court didn't receive it, but I can tell you I didn't. So.
Okay. All right. That is a stipulation that we did come to, and that was a stipulated motion to set aside the order dated 11/2/18, striking the reply brief that was filed 1/17/19.
Do you have a copy of that with you, counsel?
Yes, I do, Your Honor. May I approach, or how would you like me to?
Sure, yeah, just approach, please. And we will take it under advisement since it's an order of the court.
Thank you. And then the other preliminary issue that I had was that I had filed a motion for reconsideration that actually addressed two issues, and the court had not ruled whether or not a response was going to be, or if the court wanted a response to be filed to that. And so I would ask the court to order, following the arguments today, that a response be filed to that, and that's related to the issue where the court struck the transcripts. And I do have a copy of that motion for reconsideration as well.
Okay. Well, I think I might have seen that, so we will take that under advisement as well.
Okay, thank you. All right, and may I move into argument?
Please.
Thank you. All right.
just before we start, let's start back with 20 minutes, because I appreciate the preliminary matters that you attended to.
Thank you. All right. In this matter, the parties were married June 7th, 2008. The petition for dissolution of marriage was filed September 5th, 2014, and my client did file her response November 29th of 2014. In this matter, there was a temporary orders hearing that was held in March 23rd of 2016, and then there was a subsequent continuance of the temporary orders hearing, which occurred in July of 2016. And it's at this hearing where the court, in my client's opinion, erred in that the court would not take any additional evidence at that time and only heard argument related to the motion for summary judgment that was filed by the opposing counsel. And at that hearing, the judge, over objection, would not allow any further evidence to be presented and ruled that the motion for summary judgment that time was granted, and that he denied my client's request for temporary orders. Following that hearing that occurred in July of 2016, there was then a later hearing, a motion for summary judgment that was filed, and that was held on July 6, 2017. And in that second motion for summary judgment that was filed by opposing counsel in the trial court, the limited issues there, and there were only a few semantic changes within the motion that basically indicated that the premarital agreement related to property issues, that my client was foreclosed in essence from pursuing any property issues. And the court also granted that motion, which in essence foreclosed my client from seeking reimbursement of loans that she had loaned to her ex-husband in the total amount of $203,721.17. $85,759.61 for pre-marriage, and $117,961.56 for post-marriage.
Counsel, what's your response to the argument that that your client has waived the right to challenge those rulings by entering into a consent agreement?
Your Honor, in that regard, in relation to the signing of the consent decree, which happened on February 9th of 2018, at the time of trial, given the court granted that second motion for summary judgment, the court did specifically state that it was precluding my client from presenting any evidence related to any of the payments that I just identified pre and post marriage. So there were only a few very limited property issues which remained after the court granted the two motions for summary judgment. So the parties were able to agree on those limited issues, which were, I believe it was a vehicle and a few debts and some cell phone reimbursement charges, and they were able to agree on that. So my client didn't believe that there was a need to have a contested trial on those limited issues just to preserve her right to appeal. There was also a motion to dismiss that opposing appellant counsel filed, and that also does go through very thoroughly with my client's declaration, her understanding and her reasoning for signing the consent decree, and I'd ask the court to please look at that as far as her factual understanding, where she...
Is her understanding critical? I mean, if the law is simply that by entering into a consent agreement, can't that be part of the court's prior rulings? Can't that be part of negotiations that lead to a consent decree?
There were, Your Honor, many emails that went back and forth between the trial counsel that did specifically argue about the language in the decree, and so.
But I'm saying any kind of disagreements with previous rulings might be factored into what's ultimately agreed upon, and so doesn't that create a barrier to us looking back if the parties have agreed? They've now negotiated an agreement that encompasses everything.
Your Honor, the way that the consent decree, I think, was drafted and how the language came to be was negotiated, and that my client did not believe that she was foregoing her appeal rights to any of the lower interlocutory orders that had occurred during the pendency of the case. And the only remaining issues, in essence, that were encompassed within the consent decree were the issues that the parties did, in fact, agree on.
Does the consent decree say that?
It doesn't specifically it doesn't specifically say that my client is waiving her right to appeal.
Does it even talk about this sort of carving out of the particular the property loan claims?
It doesn't specifically speak to that, Your Honor, but there were, and in the motion to dismiss that was filed, including my client's declaration and the emails that went back and forth between counsel, the opposing party and the opposing counsel, within that correspondence, my client does believe we're aware of her intention to appeal.
How about generally? You said it doesn't specifically. Does it generally talk about it in the consent decree?
There's not a specific provision that deals with my client reserving her appeal rights. But there is also no waiver either of her appeal rights. So it's silent on the issue. And I think in looking at the court's equitable powers, and that the touchstone of determining what is fair and equitable in a divorce case is looking at the merits of the case and not allowing it to proceed by a procedural defect. And I think here there are actually three exceptions that do exist to the issue that the court is raising. And my client does believe that she falls within all three of the exceptions, and that is outlined in the reply brief also that was filed by the court. And with regard to the exceptions, my client does believe that in this case, and the opposing counsel did cite the Lee case in support of his position, and here my client does believe that the premarital agreement, and I think that the issue here that is being glossed over is that my client isn't in effect contesting that the prenup is a valid document. What she's contesting here is the fact that the prenuptial agreement, when we look back at time, and we do the look back test that Bendick, the case in Bendick looks at, and also the case in Pownell, which Arizona law does follow.
Counsel, I want to interrupt you just before you get into that. And I appreciate the argument that you're leading into, but a necessary prerequisite is that we have appellate jurisdiction to consider that argument. Now, perhaps I've interrupted you as you were addressing appellate jurisdiction. If so, I apologize. But a first question always for an appellate court is to determine whether it has appellate jurisdiction. And the consent decree, as you've heard and you know, gives us some great pause. To use civil procedure, which is not directly applicable here, an analog to what happened here is you could either approve a judgment as to form, meaning you reserve your objections and perhaps could appeal from it, or you consent to the entry of a judgment, meaning the case is sort of over, and there's significant case law saying an appeal does not lie from that. Help me better understand your argument on the fact that this was a consent decree entered apparently after some significant negotiation that at least facially appears to resolve all claims as to all parties.
Well, Your Honor, if we look at the exceptions that do apply to the situation, which I think were outlined in the Lee case, and that was exactly a distinction that I did draw from that case because that was a civil contract case that was under the civil rules. And here I think we're dealing with the family law rules. And my client does believe, again, with regard to the equitable powers of the court, and also in looking at the three exceptions that are set forth in that case, my client does believe that she fits squarely within all three of those exceptions. And the first one that we deal with is related to mistake and what my client's intention was when she signed the consent agreement, and the fact that she does believe that the husband knew that she also did not intend to waive her appellate rights. And I think within the case law that specifically outlines the three exceptions, that she does fall within each of those sections as set forth.
But would that be a decision we would reach as on mistake, just on appeal, where someone just says I made a mistake? Isn't that kind of a factual determination that would need to be raised with the trier of fact?
Well, Your Honor, with regard to the exceptions that are outlined, it's my understanding that the Court of Appeal has the discretion to make the consideration based on, and if you look at the declaration again that my client did submit with her, with the motion, the response to the motion to dismiss that was previously filed with the court, that does set out exactly how the consent decree came to be, including all of the correspondence between myself and the opposing counsel in relation to how the consent decree came about. So with that factual basis outlined in that declaration that was filed in response, I think the court can find, again, that my client does fit within each of the three exceptions. And I think the fact that she didn't raise the issue in the lower court to be able to have the court there make that determination is that it didn't come to light until on appeal, until Mr. Riley had filed the motion to dismiss on his client's behalf.
Just so we're clear on the record, the three exceptions you're referring to, are those are from Coalfield? And then I just, let me move on with the question. The first one is, the party appealing the decision is not the party who consented to entry of the judgment. Does that apply?
Cofield, yes, Your Honor, that is Cofield v. Sanders, 9 Arizona Appellate 240. And when the party appealing the decision is not the party who when
That would not apply here, I think it's safe
Right.
to say.
Okay, so let's go on to the second one, which is fraud, collusion, or mistake. Are you focused? You're focused on mistake premised upon ancillary communications around the document.
That's correct.
Okay, and what about the third one, public policy?
And that also, Your Honor, my client does also believe that she fits within that category as well.
How? Why?
Because here, Your Honor, my client did raise this issue in the lower court as well, in that she specifically did raise the issue that the effect, and the court has to look at the circumstances that my client was at the time of the dissolution of marriage, and that her circumstances at that time were that she was seeking public assistance, and she actually was approved, and she received disability, and she also received money for food and other government-related benefits. And she did testify to that at length, and that's also set forth ad nauseum in the record as well, that her condition at the time that we did have the hearing, the temporary orders hearing, and also that continued to the time when the consent decree was filed, where she was receiving and had applied for and was granted public assistance. And so there is case law that has been cited as well that states that that it is where the court can look at the prenuptial agreement and determine whether or not it's unconscionable if the individual that's seeking spousal maintenance has qualified for public assistance. And I think here that's exactly the case that had happened at the time of the temporary orders hearing in July of 2016, second motion for summary judgment, 2017, and then also at the time of the consent decree, my client was receiving public assistance.
Counsel, is that the public policy argument? Is that the same for appellate your argument that we should recognize appellate jurisdiction and that the prenuptial is unconscionable, or are those different arguments?
They're the same, Your Honor. They're wrapped into each other. All right, and then going into the issues regarding the legal arguments in terms of procedural versus substantive unconscionability, and here this goes to I think that the procedural versus substantive unconscionability isn't really relevant, because my client, again, isn't seeking to overturn the prenuptial agreement in its entirety. Her main concern here with the appeal is that she believes that the courts did not properly apply the prenuptial agreement because of two reasons. The first reason being that she believes she was entitled to temporary spousal maintenance because of the public policy argument, in that her circumstances significantly changed from the time that she signed the prenuptial agreement to the time of divorce, because she did suffer a significant debilitating and deteriorating injury that rendered her completely unable to work. And so at the time she did qualify for government assistance, and I think that, as I discussed, did qualify her. So she believes that the trial court was incorrect in its ruling, finding that she did not qualify for spousal maintenance. And then the second part of that is that the court's second ruling regarding the prenuptial agreement in precluding her from presenting any evidence at trial related to the financial issues in the case, that ruling is what led her and was the basis of her agreeing to the consent decree, because she didn't think that it would be a fruitful use of the parties' time, and I think this is also a public policy argument, that it wouldn't be a good use of the court's time, the parties' time, to litigate issues in the trial court which weren't even contested. And so it didn't make any sense to her to pursue having a trial on those issues, which in essence would have just been to preserve an appeal. And so she did what she thought was best and came to an agreement that resolved the remaining issues with the intention of filing an appeal. So my client would ask the court to remand the case back to the trial court with that understanding.
Thank you, counsel.
And I would just reserve the additional time.
Certainly. Mr. Riley.
Good morning. May it please the court. My name is Daniel Riley, and I'm appearing on behalf of the appellee, Jeffrey ORAM, in this case. For most problems in life, there is a tool to address those problems. And the court has at its disposal several tools with which to address the problems in this case. The first problem is the jurisdictional question. When a party consents to judgment, the general principle is that this court lacks jurisdiction to hear any appeal from that consent order. And so the first tool at the court's disposal is to dismiss this appeal for lack of jurisdiction. The second problem in this case is the problem that the record is not complete. Many of the claims being made on appeal are fact-intensive claims that require the court to review the transcripts, to review the record, to make a determination as to whether or not the trial court abused its discretion in reaching conclusions that it reached. And the court can't do that in this case because wife did not comply with the rules to file their transcripts on time, to provide copies to opposing counsel. So the second tool at the court's disposal is to affirm the consent order on the basis that there is no record on appeal from which the court could really evaluate wife's claims.
Can you give us your take on the exceptions raised in the Lee case?
Yes, Your Honor. The exceptions I believe you mean the Cofield case.
Yes.
The first exception is whether there is an identity between the party who consented to judgment and the party who is appealing judgment. In Dowling versus Stapley, for example.
Counsel, I think it's undisputed that doesn't apply.
Right. So that issue doesn't apply. The second issue is whether there is a question of mistake, fraud, coercion, duress. The argument being made on appeal is that wife was mistaken in that she didn't understand that by signing the consent decree, she was depriving this court of jurisdiction to hear any appeal. Even assuming that's true, and even assuming that wife had presented that to the trial court, which she didn't do, it's not sufficient to maintain that there was a mistake. The doctrine of mistake is a question of whether there is a mutual mistake. And the most that wife has claimed is that she had a unilateral mistake as to the effects of signing the consent decree.
What are you saying would have been her vehicle for presenting that to the Superior Court?
Well, she had three different paths she could have taken to preserve this court's jurisdiction here. When the court entered its ruling on the motion for summary judgment, she could have requested that that be certified as a final rule subject to immediate appeal. She could have filed a petition for special action. She could have chosen not to sign the consent order, and she could have proceeded to trial. So those were the three different paths.
But I'm saying the mistake issue, that she mistakenly believed that signing the consent agreement didn't preclude appellate relief.
Her option at that point would have been to file a motion to revest jurisdiction in the trial court, to file a motion to set aside the consent decree on that basis, which, again, she didn't do. That was yet another path available to her that she has not availed herself of.
So, tell me, counsel, let's say in the negotiations leading to the consent decree, assurances were provided on behalf of your client that these claims were preserved, and your colleague enters the consent decree on that basis. Would that qualify under the second exception of Cofield?
Hey, I think you would have a problem of fraud in that case, because you're offering someone something in exchange for them agreeing to a consent decree, something that's outside the terms of the consent decree, in order to induce them to sign it. And I don't think that's what wife is arguing in this case. I don't think she has said that she received any promise that those issues would be preserved, but I think there would be a valid argument for fraud under that circumstance.
But you're suggesting it would have to be raised in the Superior Court.
Correct, Your Honor. The option at that point would be to file a motion to revest jurisdiction in the trial court, present that argument to the trial court so that there was a record developed from which the party could then bring to this court so this court could properly evaluate it. It's not proper for a party to simply sign an affidavit and conscript this court into the role of becoming a fact finder. The third exception is whether or not the consent decree violates public policy. But wife's argument is that because of the terms of the consent decree, she may qualify for some kind of public aid. I don't know whether that's true because I don't have the transcripts from the trial court case. If we assume that the portions of the transcript cited in wife's brief are accurately quoting the transcript, the most it demonstrates is that wife, for a temporary period of time from December of 2014 to December of 2015, during that period was receiving some kind of public benefit. And assuming that that's true, the Uniform Premarital Agreement Act states that you evaluate whether someone is qualifying for public benefits as of the date of the divorce.
So let me ask you it's a similar question I asked to appellant's counsel. For the unconscionability question and the enforceability of the prenuptial and the public policy exception to the consent decree, do you view those as the same standards?
I believe it's the same argument, not necessarily the same legal standard.
How does it differ?
The issue with whether or not it violates public policy, public policy is expressed in this case by statute, by the adoption of the Uniform Premarital Agreement Act. And that act does state that when you have an otherwise valid and enforceable premarital agreement that waives spousal maintenance, the trial court may, and it uses the term may, not shall, it may waive that provision of the premarital agreement only to such extent as is necessary to remove that person's qualification for public aid. It gives the trial court discretion. It's not a mandatory exception. So to stretch and say that any consent agreement that may result in someone receiving public aid violates public policy, I think that's reaching too far.
And I understand what you're saying. How then, though, does the lens through which we view a consent decree or consent judgment to determine whether this public policy exception should apply and we should exercise appellate jurisdiction, how does it differ from what you just described?
I think it would be the same if the statute used the term shall. That is an express statement of public policy. By using the permissive term may, the legislature is leaving it to the discretion of the trial judge, because the trial judge is in the position to view the facts, to look at the demeanor of the witnesses, and make that determination whether or not that's appropriate under those circumstances. And so that carves out an area in which it's not a forceful expression of public policy sufficient enough to meet the exception to the jurisdictional issue. And in the reply brief, counsel conflates two completely separate issues. There's the jurisdictional question, and then counsel brings up a waiver argument. And I accept some responsibility for that. In my response brief, I inartfully used the term waive when I should have used some other verb. Waiver is a completely different doctrine. It comes to us from common law. It's derived from ancient principles of contract law. The issue on appeal is not whether or not wife has waived her right to appeal, but whether or not this court has jurisdiction to hear the appeal. Wife jumps past that question and assumes that the court has jurisdiction, and the question is then whether she has waived that jurisdiction. There was never jurisdiction to be waived, and that's made clear in the Lee versus ING investment management case. It's not a question of waiver.
Let me ask you, one way to look at this case, a way that I'm certain you would not agree, is that your client received more than $200,000 from his now ex-wife that he will have no obligation to repay, ever. Does that, and again, I'm not asking you to concede that by any stretch, but does that sort of allegation fit within, or is that relevant to the public policy issue with respect to appellate jurisdiction, or should we ignore that?
Assuming it's true, and I don't know if it's true because, again, I haven't seen the transcripts. I wasn't trial counsel.
No, but presumably you've had an opportunity to speak with your client.
Right. So assuming that was true, public policy is that the court, in a dissolution matter, should divide property in a fair and equitable manner. And as I understand it, wife articulated her claims in terms of whether or not sole and separate property was transformed into community property, which is an older common law way of looking at things. In the Valento versus Valento and that line of cases, the court has made it clear that we don't use that principle anymore in family law. We now look at things in terms of what is a community lien. And in terms of a community lien, we need certain information. We need to know the value of the property on the date of marriage, the value of the property as of the date of divorce.
I thought the issue here was wife's separate property becoming husband's separate property.
Right, and so she was arguing that in doing so, the sole and separate residences had been transformed into community residences.
Wouldn't she also just have a claim that there's a lien against if it's husband's sole property, if she made a loan, and he now has equity in his sole and separate property, couldn't she make an argument that she's entitled to a lien?
She could have. That would be a community lien claim. And there's a mathematical formula.
Or is it a community? If we're just talking about the prenuptial agreement says her separate property remains her separate property, his separate property remains his, why has anything become a community asset? It's her separate property.
I apologize, Your Honor. I misunderstood your question.
And I guess just kind of a preliminary question, does the Superior Court have authority to address a dispute on whether her separate property became his separate property without a lien attaching somehow?
Yes, the trial court has a statutory obligation to affirm to each party their sole and separate property and to resolve any claims associated with their sole and separate property. So to the extent there was any reimbursement claim, the trial court had jurisdiction to address those particular claims.
But they, in theory, could have been brought without, as a separate matter, assuming it's not part of a negotiated consent judgment.
That is correct. So the wife did not have an exclusive remedy to pursue that through family court. She could have also, for example, pursued it in a separate civil unjust enrichment claim or some other claim through civil court.
But you're saying she did pursue it in this action, and thus it's covered by the consent decree?
That is my understanding. Again, the record is not clear to me. Based upon the judge's orders, there's descriptions of what the judge said in wife's briefs that would give some context to those orders. It's not clear to me whether that was specifically addressed and denied in any of the trial court's orders. But to the extent it was brought up, then it's been waived at this point pursuant to the consent decree, because the consent decree includes language specifying that each party has waived their right to trial, that this is a final decree that resolves all of their issues. Moving on from the jurisdictional issue, the third problem the court faces is the problem of the incorrect legal standard being cited with regards to the spousal maintenance claim. Throughout her brief, wife cites to cases that predate the adoption of the Uniform Premarital Agreement Act, cases that are outside the jurisdiction of Arizona that do not cite to the Uniform Premarital Agreement Act. And so she uses terms like this. She argues the trial court should take a second look, should verify whether the vitality of the agreement is still intact, whether there has been a change in circumstances. All these terms come from the older common law method of evaluating a spousal maintenance waiver in a premarital agreement. And Arizona has done away with the common law method. In 1999, we adopted the Uniform Premarital Agreement Act. We now apply a statutory system for determining whether or not to give effect to a spousal waiver in a premarital agreement act. And that statute is much more restrictive than the common law method. The Uniform Premarital Agreement Act specifies that to the extent there is any second look, it is focused solely on whether or not the person, because of the lack of spousal maintenance, qualifies for a public benefit as of the date of the divorce. And from what I can gather from the record, there was no evidence that wife qualified for a public benefit as of the date of divorce. The most that was demonstrated was that a period of time from 2014 to 2015, she may have received some kind of state benefit during that period, which would not be sufficient to trigger that statutory claim.
So let me ask you, if on the merits, to follow up on Judge Catani's question with respect to the round figures, 200,000 or so, If we were to address the merits of that, what's your argument there, given what you've told us so far about your view of the vagaries of the record? We are even more strangers to this case than counsel is.
So what would be my view if there was a record that would demonstrate that there was $200,000?
What's your view on the current record? Because I heard you almost say you weren't sure whether the issue was raised, but then I think you said the issue was raised and was resolved in by definition, given the terms of the consent decree. But if we had appellate jurisdiction, what's your argument on the claim for either a lien or payments from sole and separate by wife to sole and separate to husband?
Well, I accept counsel at her word when she says that it was raised at the temporary orders hearing or at some other telephonic status conference. In my review of the orders entered in this case, I did not see a specific order denying that particular claim. So to the extent it was raised, I don't know that there is a specific written order that addresses it.
If there's not, I guess going to the question, if we're addressing the merits, and if the evidence is wife made a loan of $100,000 from her sole and separate property to husband, and now it's $100,000 in his bank account, does she have a claim against that?
I believe she would. If the record demonstrated that she had made a loan of $100,000 and the trial court had evidence from which it concluded that this was in fact a loan and not a gift, then she would have a claim there. But anytime money is exchanged between married parties, there's always a presumption that this is intended to be a gift. And the party that is looking to override that presumption.
But if there's a finding that it's not a gift, I don't recall. I remember some discussion in the briefing, but so if the court would have to make a finding that it's not a gift, and then it would be, if it's not a gift, you would agree then that she would be entitled to a lien or to.
I would. If the trial court had concluded that this money was in fact given, that it was not a gift, I don't understand how no claim would lie for that.
And if the trial court did not address it in its order, is it your position? Is it your view that mother could raise it as that it's not covered by the consent decree?
I do not see any language in the consent decree that specifically says the parties have waived any and all other claims against each other. So my interpretation of the decree is that if it wasn't raised at trial, then it's a claim that has not been resolved by the consent decree and could presumably be brought, assuming statute of limitations didn't apply, could presumably be brought as a separate civil claim. But again, from the record that I have, I can't determine whether it was raised. If so, I don't see any specific order addressing it from the family court. And if the court has no other questions, I don't believe I have any other comments to make at this time.
Thank you, counsel.
Thank you, Your Honor.
Rebuttal?
The motion that I was referencing, that was actually the response to the motion to dismiss that was filed that includes my client's declaration. I do have an extra copy of the declaration with me that I could provide to the court, and that was e-filed with the court July 25th, 2018. So I just asked the court to consider that declaration of my client that explains her intent. And I think I would like to clarify something, because I know Your Honor, Thuma did ask me about the first exception, and I think the way that it is worded summarily, it appears on its face that it would not apply. However, if you broaden that somewhat and look at what is included there, I think it can be expanded in that it does go to my client's intent. And in my reply brief on page 2, 3, 4, I spent a significant amount of time there explaining her intent as well, and how she, in order to establish that there's a waiver, that there must be a relinquishment of a known right or conduct which would warrant inference of an intentional relinquishment, a clear showing of intent to waive is required for waiver of rights, and that's under Goglia v. Bodnar, which is 156 Arizona 12. So I just wanted to clarify that I think that that can be broadened and that that first exception does actually apply in this case if you look at it from my client's intent. In looking at the argument that opposing counsel makes with regard to the record not being complete, I did actually print off a copy of the electronic index of record for this case, and it does show that the transcripts were in fact ordered by myself from the court reporter. May 22nd, 2018 is the date that it shows that they were filed, and then this court did request on January 7th that a supplemental index of record be prepared from the lower court proceeding, and so those transcripts were actually brought up to the Court of Appeals and are part of the record in accordance with the court's request for that additional information that was provided to the court. And that is also an issue that's part of my motion for reconsideration given the circumstances related to the transcript. So I think that the record is complete with those transcripts being provided to the Court of Appeals.
Counsel, just to clarify, it's your position that those transcripts were submitted to the Superior Court and that request for supplementation by this court earlier this month would include them?
Yes, Your Honor. According to the amended docket that I have, does show that those transcripts were provided.
In January, this month?
Yes.
Okay. From the Superior Court?
Correct.
Got it.
And counsel, I know you're running out of time, but could you address, in your view, did the Superior Court address the issue of whether separate property, whether your client was entitled to a lien or payment from separate property based on monies that were loaned?
I do believe that the court did, and in fact, admitted Exhibit 90 shows the proof of all the payments that my client made, including bank account transactions, and that's a very voluminous exhibit that does support, and that was...
I think the court's ruling encompasses that.
It encompasses the court's ruling made on July 7, 2017, granting the second motion for summary judgment, which precluded my client from presenting any evidence related to those loans and payments, is specifically addressed in that, because that was the crux of that second motion for summary judgment, was that they were trying to bootstrap in all of the other financial issues into that motion for summary judgment, so that my client would then be precluded at trial from presenting any information on any issues that were financial, because the court had found that the prenup precluded that, and that's exactly why my client is appealing.
Counsel, thank you very much for your argument, and we will take the matter under advisement at this time.
Thank you.
You're adjourned.